Welcome to your real estate journey. Expert tips for buyers and sellers. I am Dolly Lopez, realtor and real estate broker in both states of Florida and Kentucky. In this podcast, I will guide you and provide you with strategies and tips to make informed and successful decisions regarding real estate. Today, like every Thursday, I am joined by my favorite real estate attorneys, the VPPs, Leslie and Valerie. Welcome, ladies. How are you all?
We're great, Dolly. Thank you so much for having us today. We're so excited to be here with you.
I am very happy to have you every single week, guiding our clients, educating our clients regarding real estate. And today we'll talk about title and how we can resolve issues with title whenever we're purchasing a property, and how to take title as well. So let's start by saying there's a lot of people that will come to me, and it just depends. It's more towards one culture than others, but I get a lot of clients asking me, do you should I take the title with my husband or with my spouse? Should I do that? And what about if I am not married but I want to add my partner to a title? How does that work, and do you suggest doing so?
So that we're very clear, when you're talking about adding a spouse to title, it has to be because you're legally married, right? That's a key question that we always ask all of our clients is whether you're legally married. And when I say legally married, you could be married in Africa, you could be married in any other country, but if you are married here in Florida and in the United States, every marriage is recognized, right? So it doesn't matter that you got married in another state, doesn't matter you got married in another country, doesn't matter if you got married in the other side of the world. It is recognized in Florida. So when an attorney asks you who's doing the title of your property is asking you, are you legally married? You have to respond yes. And it's not just because we need to add your spouse to the title, it's because we need to add your marital status to the title. And that being said, if you are married, you will own the property as a married woman. That, or as a married man, that part, as a married woman, as a married man, that's what protects your spouse if something were to happen the day of tomorrow and you guys were to get divorced or whatnot. That's what protects your spouse, and that's what kind of puts notice on everybody saying, hey, if this house ever were to be sold, we have two people here, not just one. So it's always my recommendation to do what is legally done, right? So if you are legally married, put you are a married person. If you're single, then put a single person. Now, another question, and to follow up to your second question, is whether or not to add your significant other or your friend or a cousin or a family member, whatever, to the title. Something that everyone should be very well aware of is by adding that person to the title, and you're giving them ownership rights of that property.
And
And
that
when I
is regardless if they put any money into it or if they didn't. It doesn't really
doesn't
matter.
matter.
Doesn't
Doesn't
matter.
matter. They could not be paying you anything. They could not even be, it's probably they're not even living in the property, right? They don't even have to be living in the property. So long as you decide to add them into the title and their name is now reflected on what's called a warranty deed, which is a legal document that says who is the owners of these property. If their name is added to that, they have ownership rights, and those ownership rights will translate the day of tomorrow if you sell the property, because they will have to have their share of the proceeds of that sale, whether or not you like it or not. So something you need to keep in mind if you add someone to title is that, are you willing to share the profits of this property? Are you willing to share the ownership rights of this property? Because another thing you need to be very well aware of, and something that Les and I handle a lot, is we have clients who are dating, then they break up, and the boyfriend or the girlfriend, the significant other, who has never put any money into the mortgage, has never paid any of the utility bills, didn't put anything down when they actually bought the property, is now going to sue you for a partition, which means they're going to request the court to force a sale of the property and give that person X amount of money of the sale, depending on, how it is you own ownership, how it is title is reflected. So if you're adding someone to title, be very careful.
Yeah.
And make sure you reach out to an attorney to understand the full concept of that.
Gotcha. But it's legally possible. right?
100%.
Completely.
100%. It's 100% possible. It's 100% legal. You can do a deed and do a quick claim deed, what we call a quick claim deed, to add somebody to title, so long as if you have a mortgage on the property, you're not removing the borrower who's on that mortgage. So for instance, if I'm on a mortgage, it's me, Valerie, and I decide I want to add Leslie to my title, I cannot remove myself and add Leslie,
Correct.
because then I'll have issues with my mortgage company.
Gotcha. Makes sense. What would you say to this parents that say, I'm going to add my child to the title because if I were to pass away, I wanted to make sure that my kid is protected and the house goes to them. But the kid might be 5, 6, 7 years old. What would you suggest in
Never
that
do it.
case? Because there's other methods.
I never do it.
Okay.
I would tell
That's
that.
what I suggest as well. But just want to, you guys are licensed real estate attorneys. Well, just
Right.
attorneys, period. You just do real estate and then litigations and a bunch of other laws. But what would you suggest?
Not do it, because if what you want is to protect your investment to go to your children, because you want them to enjoy, your efforts throughout your life, there are many other ways that you can make sure that all of your assets, not only your property, not only the home that you built, not only the home that you bought at a great price in whatever time, go to your children. There are many ways. You can do a trust. You can, set up a company to be the holding company of the property, and then a manager will make sure that the property goes to your children. If something were to happen to you, you can do a will, and that will would specify which property goes to whom, right? As long as you have, your last will, your last wish, your last desire set up in a properly and legally, set up, it's gonna go to you, to whoever you want, not only your children, but it's gonna go, and it probably will have to go to court if you don't do it, if you don't use a trust. But still, the court will abide by your wishes, but will abide by the documents that were legally executed by you. And then adding a child to a title, it only adds on problems. That, let's say you want to 10, 20 years from today, you think that it's a great investment opportunity to sell that property. And let's say your child is still a minor, because if it's only the child today, it's 1 year, right? And in 10 years, still a minor. You will need to go through a legal process for somebody to authorize the signature on behalf of the child, because the child doesn't have legal capacity. And that's something that the child needs to have in order to transfer title. So putting or adding a minor into a title, it only creates problems, and it's only going to cost you money, because any attorney will have to charge you a significant amount of money to make sure that the transfer that includes a child in the transaction goes through as required by Florida law. So you're just adding a problem to you. You're adding charges as well. So there's no reason to do that. There are other ways that we can make sure that it goes to your children if that's what you want.
Yeah.
Yep. This question actually comes from one of our followers on YouTube. And the question goes as follows. A family member willed their property to me. How is the process of transferring title to me, and what are the fees associated with it?
So an important question there to answer a question with a question is, how is it that you got that property? Was it through a will? Because if what you did was you got it through a will, well, then now we have a legal process that we have to start within the court system that's called probate, right? We have to enter into a petition. We have to petition the court to say, hey, court, here is a will that I am the beneficiary of this property according to the will. This person's passed away. Here's the original will. Here's the death certificate. Please transfer the property as stated on the will. And that is a legal process, just so that everyone's well aware of. A probate is something that could take 6 months to a year, even more, depending on what it is the will says, what's being transferred in the will. Because most of the time, a will is not going to be as simple as just saying, hey, Mary, when Mary dies, Dave gets the house. It's going to be a lot more than that. There's, typically there's maybe going to be bank accounts involved in that will. There's probably going to be multiple properties in that will. There's going to be there could be jewelry that's involved in the will. So all of that has to be done correctly and has to be done before the court system. So it has to be a court order that that's entered by a judge that actually transfers title from the person who is deceased to now the person who's entitled pursuant to the will. So it is a legal process that you will have to contact an attorney in order to be able to get that property under your name.
Gotcha. And then, so moving from that question, what happens if someone were to lie on a deed? And within this, because I actually had a client, and I forgot to mention this before, but I actually I have a client that the grandfather willed a property to that person. But my client was in another country then. Now she wants to see how she can have access to that property. But the wife, I mean, it was a long story, but the wife of the grandfather, I believe, took possession of that property, and she tried to make all the efforts available to her for this grandchild to sign off on a release, giving her
Right.
like $100 or giving her
In
something.
order to transfer the property to
They
her.
never did. They never signed anything. However, how can this client take possession of that property that she doesn't really know anything about? Does that make
So,
sense?
yeah, so that's, and I mean, correct me if I'm wrong. I think you stated there was a will, right? There was a will that gave
Yes.
it, the grandfather left a will giving it to the grandchild. So, same, the grandchild is going to have to take that will to court and do a petition for administration, which is saying, hey, court, here is the will. Now, and the issue that the grandchild may have is I don't know if they have the original will or not, right? So if they don't have the original will, then it's going to be another process about how to establish that, you know, a copy of the will is in fact a true and correct copy of what the original will was. And in that kind of situation, just know that it's more than likely that this will be contested by the grandfather's wife who's still alive.
Right.
Because it's more than likely that, you know, a petition is going to be filed. And just to give a quick run through of what a probate is, once you actually submit the will to the court and say, hey, court, here's the will, the court's going to say, okay, no problem. I need for you to tell me in the deceased, right? The person who passed away, who are the children that the deceased have, and who, if they have a spouse, what's their name? All those people are going to have to be notified that there is a probate going on. So if they feel they have some kind of right to a property that was owned by the deceased, then they're going to file what's called a contested probate, where they're going to contest, hey, court, wait a second, I'm wife, right? Because the grandfather had a wife, I'm a wife, I'm entitled to that property.
And the important part in Florida is that the person that willed the property and was married didn't have full rights over the property to do like an outright transfer because of the homestead protection, right? So what ends happening in court is that the wife has a life state right, so she can say go to the court and say, no, I am the wife. We were married at the time that he willed the property. We were married at the time that he died. We have been living in this property. It's our homestead exemption. And what happens is that the court's hands are tied. She's going to have a life estate right, and she's going to have the right to live at that property until she dies. Now, once she dies, then the property could go to whoever, you know, was will or had the right within the will, if the will is, you know, is probated correctly and in there has any other claims or whatnot. Let's just say everything went perfect, right? Then still she's going to have the right to leave during the time of her life, and after that, then it will pass to whoever that person that died decided it was going to go through. But think about it, it could be years, it could be decades, you know,
That happens.
yeah.
And so that even goes back to our original topic of, you know, am I married or am I not married? What do I put on the title? That this is one of the things that could be affected is the fact that, yes, I probated I did a will and I left it to my grandchild, but I'm married. I'm legally married. And in my will, I mean, in my deed to the property that I live in says that I'm legally married. So that already tells the courts, wait, there are protections for a spouse. Spouses are protected even though they're not listed. in a will, even though they're not specifically mentioned in a will. So that is something that's very important that people need to
I
know.
believe this grandfather had multiple properties. So I don't think this was the homestead property itself.
Well,
Uh,
it's not homestead, then there's nothing that she could do. Even if she was the widow, right? She has no rights, because unless she can go to court and prove that he used
Marital assets.
marital assets to purchase the property, or that marital assets were used in, you know, giving up the value of
Yeah,
raising,
improving the home, right?
right? She's not gonna have a claim or any right as to that property, because if let's think about it. I am the owner of an investment property. It's not where I live, it's just a property that I own, but it's not listed with anybody else. That means I have the right to list it in my will, to to give it to anybody at any point. I don't have to die. I can just go and sign a quick claim deed over to whoever I want them to be the new owners of my investment property. So nobody else has a right over me. Now, she can claim that marital assets were used in raising the value of the property, and that she's entitled to some amount of compensation, but that doesn't mean that she's going to have any rights over the property,
Right.
you know?
Gotcha. That
It's
makes sense.
complicated.
It is a little more
Yeah.
complicated. And when something like this were to happen, what I suggest as a real estate broker, to actually go to a real estate attorney,
Yes.
Yeah.
and they will figure it out.
Yeah.
You guys can
Yes.
just talk about it, and they will guide you through the entire process. Now, guys, what would you recommend to investors, or not investors per se, but someone that wants to start investing in real estate and purchased another property? Should they take title into a company name like an LLC or an S corp, or on their personal name? And why? Why your recommendation?
So that question is kind of a two-pronged question, right? Because first we have to say, okay, it's an investment property, so great. So now we're not talking about having to have homestead exemption. So
Mhm.
that clears that. Now, second question, are we buying it in cash, or are we buying it with a mortgage? And
Mhm.
that's very important to know, because if you're buying it with a mortgage and you individually are the one qualifying for that mortgage, then just know that it has to be under your name individually. And why? Because mortgage companies and Florida law requires that a mortgage reflect a deed identically. Meaning, if I take out a mortgage to purchase a property, me, Valerie Hassan, and I am the borrower on that mortgage, Valerie Hassan, then Valerie Hassan has to appear on title. So I have to own it individually. I'm restricted because of the fact that I'm getting a loan. Now, am I buying it in cash? Because if I'm buying it in cash, then I should 100% put it under an LLC, because it's going to protect my rights. And when I say protect my rights, I mean the day of tomorrow, let's say I get sued by, a tenant for XYZ reason, then that tenant is going to be limited in what they can access financially under my name. It's going to be limited to my LLC and what my LLC makes and what the LLC has in an account, not me personally. And if I get a judgment for XYZ reason, it'll be a judgment against the LLC. It's not going to be against me individually, which makes a big difference, and protects you individually, of course, and protects your individual assets as well. Any bank accounts that you have under your name, any assets that you may have under your name, all that's protected when you put that property into an LLC.
Gotcha. And also, whenever you put it onto an LLC, if you have multiple LLCs, for example, and as long as you're not commingling money between one business to another, or personal and your business, the only if you were to get sued, the only company is just going to be against one company rather than the other ones, or personally, which it ties back to what you said, Valerie. So definitely, whenever we're taking title, it's important to talk to a real estate attorney, s-
To know
to
your
let them know what you want, and they can give you options, and they will discuss what the options that you have, and they will discuss why you should or you shouldn't take title in a certain way or manner. But guys, thank you so much, Leslie, Valerie. Thank you for joining me today. Like every single week that you guys do to educate our clients, I really appreciate your time. Guys, if you have any questions for Valerie or Leslie, how can they contact you?
Very
So,
easy. Our
mhm.
phone number is on the screen. It's 305-549-8280. They call the office, and the intake people from the office, they're going to ask questions as to what exactly they need help with. And we're going to be able to see whether me or Valerie are able to sit down and have a consultation, or whether they need another specialist or another type of attorney that can help them or guide them through whatever legal needs they have at the moment. And they can also email us, just our regular names, Leslie at vpplawfirm.com or Valerie at vpplawfirm.com, and we're going to be able to respond them or guide them as well.
Awesome. Guys, thank you so much. Thank you all for following and sharing our page and commenting. So if you want another question to be answered, please just comment below and then we'll definitely try to address it for our next video. Thank you all.
Thank you.